Well, good morning, everybody. It's my great pleasure and honor today to introduce our keynote speaker. Professor Randy Barnett teaches constitutional law at Georgetown Law, where he directs the Georgetown Center for the Constitution. A graduate of Northwestern and Harvard Law School, and a former Chicago criminal prosecutor, he argued the medical marijuana case in Gonzalez versus Raich in the Supreme Court before devising and leading the constitutional challenge to Obamacare. He received a Guggenheim Fellowship in Constitutional Law and the prestigious Bradley Prize. Randy has authored three important books. The first is The Structure of Liberty, Justice, and the Rule of Law. The second is Restoring the Lost Constitution, the Presumption of Liberty. And his latest book, of which we have copies for everyone at the back of the room or as you leave after this session, is Our Republican Constitution, Securing the Liberty and Sovereignty of We the People. And after we end this session, Randy, we're going to find a space for Randy to sign copies of the book for anyone who would like that. Randy's intellectual achievements are genuinely impressive. He is one of America's most original and capacious legal thinkers, and he has been a long-time and principled defender of a free society. Ladies and gentlemen, please welcome to our 11th annual conference on the foundations of a free society, Professor Randy Barnett.
Well, thanks so much, Brad, for the introduction. Thanks so much for inviting me here. It's a great pleasure to be here. I've never been to Clemson before. I'm trying to see if this keyboard will move in. I've never been to Clemson before. It's such a nice place to be. I do notice that there seems to be a lot of orange color around. I'm not sure why. It's a strange decorative touch that seems to be everywhere. But I'm very pleased to be at this wonderful conference and look out here at all these bright, shiny, wide-awake, smiling faces. I'll try to wake you up, don't worry. But I have to run out. Unfortunately, at noon, I have to take a flight. I have to get a car to take a flight back because my daughter is expecting her first child, which is our first grandchild, and my wife didn't even want me to take this invitation just in case. But so far, everything's fine. And I think I'm sure I'm gonna get back in time. I think right now the clock is safe. So at any rate, I'm here to talk about my book, Our Republican Constitution, Securing the Liberty and Sovereignty of We the People. And I think perhaps the most stimulating way that I could do that is by pitching a proposition to you, and that is to explain how John Roberts gave us Donald Trump. My book explains how John Roberts gave us Donald Trump. Now, I have to admit, my book was written before I had any idea that Donald Trump was going to be a serious candidate for the presidency, and I'll say a little more about that later. But so the book doesn't actually address this, but if you read the book, it will explain, I think, why and how John Roberts gave us Donald Trump if you combine the book with my talk this morning. And my book does start by talking about my involvement in the Obamacare challenge, starting from when I was on a blog that was run by the Politico, and I first made the objection to the individual insurance mandate as being unprecedented and therefore beyond both the powers of Congress under the original Constitution as well as anything the Supreme Court might have authorized up until that point. If it truly was something new and unprecedented, then there could not be a precedent that squarely justified the use of government power to compel you to do business with a private company. And that argument first occurred to me while I was as I say, on this blog. The book tells the story of how I got involved in the legal challenge and developing the argument, beginning with a Federalist Society National Lawyers Symposium at the Mayflower Hotel in November of 2009, and I walked into the corridor. The book tells the story about how I walked out to the corridor. A bunch of friends of mine were discussing the Affordable Care Act, which was then currently housed in the Senate committee, and no one knew exactly what was going to happen and when it was going to come out. And Todd Gaziano from the Heritage Foundation said to me, do you want to do something about it in this group? And I said, sure. And then he said, well, if whatever we do, we're going to have to do it fast because this bill is coming quickly. And then basically the book explains how within a period of 5 weeks we wrote a legal memorandum for the Heritage Foundation explaining why the insurance mandate was both unprecedented and unconstitutional. And then we presented it, the paper, at a program that Heritage put together in December of 2009, at which Orrin Hatch was the keynote speaker. And then after that, we met privately upstairs with staffers from the Hill, because although senators have a procedural prerogative to make a point of constitutional order to any bill, if they do, there would then be a debate on the constitutionality of the bill. And then there would be a vote, and the votes are always done according to a party line vote, that whoever's for the bill says it's constitutional, whoever's against the bill says it's not, so it's somewhat of a perfunctory exercise. The Republicans in the Senate were not going to make a point of constitutional order to Obamacare because the senators and their staff could not think of an objection to make under existing constitutional law. And this, I hear some groans out of the room, but this is actually, as will be explained to you somewhat in the book, this would not be a surprising occurrence because constitutional law has grown so capacious as to allow Congress to do almost anything. And there are many, many law professors who believe it allows Congress to literally do anything that doesn't violate an express prohibition of the Constitution. And for this reason, they're not to be totally condemned for not seeing a viable constitutional challenge. But we briefed them on our argument upstairs after the public meeting, and it was after that that they decided they would make a constitutional point of order. They'd raise a constitutional point of order. A debate was held on the constitutionality of the Affordable Care Act on December 23rd, the day before the bill went to a vote on Christmas Eve. It was broadcast on C-SPAN. My Heritage Foundation paper, co-authored Heritage Foundation paper, was then cited, and then I started fielding press inquiries about the nature of our challenge. And it was after that that we were off and running. And the book tells the story about what happened after that. In fact, what happened in the next 2 years was nothing short of remarkable. We went from a constitutional argument that was considered off the wall, and for some even frivolous. Well, there was one law professor who argued on a blog that the argument was frivolous, meaning that any lawyer who signed a complaint or signed a pleading that made such an argument should face sanctions for having made a frivolous argument. Unfortunately, I hate to say that this law professor was now subsequently hired by Georgetown Law as one of my colleagues. So we'll remain nameless. But be that as it may, not only did we go from having an argument that was considered off the wall and potentially even frivolous, we garnered 5 votes. We've garnered 5 votes for our argument that the individual insurance mandate was beyond the power of Congress under the Commerce and Necessary and Proper Clause, even under the Supreme Court's capacious readings of the Commerce and the Necessary and Proper Clause. We did that. We got 5 votes for this theory that people thought was just crazy. Law professors thought was crazy. And yet, we lost. We got 5 votes for our theory out of 9. I just want to tell you, there's 9, so we got 5, a majority. And yet, we lost. Now, normally, when you win on the law, you win the case. That is the way it's supposed to work. But although we convinced 5 justices of the soundness of our legal argument, still, we lost. And we lost because getting the Constitution right was not enough to win. We also needed a better understanding of the proper role of judges in a constitutional republic, something about which many conservatives have been wrong for a very long time. Now, my last book, Restoring the Lost Constitution, that Brad mentioned, was about how getting the Constitution right means identifying its original public meaning. And then, in the book, I talk about what that public meaning is with respect to various clauses like the Commerce Clause, the Necessary and Proper Clause. The new book, Our Republican Constitution, is about the proper role of judges in enforcing that meaning. Since the rise of the modern conservative movement, conservatives have preached judicial deference to popularly elected legislatures under the rubric of what's called judicial restraint. And even after my friend and hero, Ed Meese, as Ronald Reagan's Attorney General, added a commitment to originalism, the original meaning of the Constitution, to the conservative constitutional agenda, conservatives like Robert Bork professed adherence to the Supreme Court's precedents that had overridden that meaning. As he said during his ill-fated confirmation hearings, the current broad powers upheld by the Supreme Court under, now I'm quoting Bork from his testimony, under, quote, the Commerce Clause and the federal power generally was probably not intended, but these precedents have to stand because it is too late in the day to overrule them. Too much has happened, too much has grown up around them, statutes, institutions, expectations, and so forth. I have said, I meaning Bork, I have said that about a number of areas. So I don't think an originalist, a person who believes in original intent, can do without a doctrine of precedent. Otherwise, he would be constantly trying to rip up the nation and its laws, and you can't do that. Or, as Justice Scalia put the matter with his characteristic bluntness, quote, I may be an originalist, but I am not a nut, unquote. Moreover, Bork, Scalia, and other good conservatives refused to acknowledge the original meaning of such rights recognizing provisions as the Ninth Amendment and the Privileges or Immunities Clause. The Ninth Amendment says the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. The Privileges or Immunities Clause says no state shall make or abridge any law, shall make or abridge any law which violates the privileges, shall make or abridge the privileges or immunities, no state shall make or enforce any law that abridges the privileges or immunities of citizens of the United States. If you came down from a planet and someone told you those were in the Constitution, you would think those are pretty darn important, wouldn't you? And yet the Supreme Court has told us that these provisions mean nothing at all. I'll get back to that in a moment. On the other hand, when Justice Scalia was confronted with a Ninth Amendment argument in the case of Troxell versus Granville, a case decided in the year 2000, which involved the right of a parent to raise her child as she saw fit, which I would point out to you is not enumerated anywhere in the Constitution. So if your view is the Constitution only protects the rights that are enumerated, then the right to raise your own children is not a protected constitutional right under that theory. At any rate, the issue of whether that was a right or not was raised in the Supreme Court in Troxell versus Granville, which upheld such a right in a 5-4 decision in which Justice Thomas was in the majority and Justice Scalia was in the dissent. Rather than deny the original meaning of the Ninth Amendment, in his dissenting opinion, Justice Scalia asserted the conservative mantra of judicial restraint. And here's what he said in his dissent. In my view, a right of parents to direct the upbringing of their children is among the unalienable rights with which the Declaration of Independence proclaims all men are endowed by their Creator. And in my view, that right is also among the other rights retained by the people, which the Ninth Amendment says the Constitution's enumeration of rights shall not be construed to deny or disparage. So far, so good, right? Now he goes on. The Declaration of Independence, however, is not a legal protection conferring powers upon the courts, and the Constitution's refusal to deny or disparage other rights is far removed from affirming any one of them, and even farther removed from authorizing judges to identify what that might be, and to enforce the judge's list against the laws duly enacted by the people. So you see the move that he's making here? It's a standard move. Shift from the subject of original meaning of the text, which for this purpose he concedes covers the right in question, to the argument about judicial role, which gets you away from talking about the text into talking about what judges should be doing about this or that. It's a very crucial intellectual move that gets oftentimes overlooked when it's being made. Now, it's quite likely that Justice Scalia conceded the original meaning of the Ninth Amendment would apply, because he knew he was in the very next sentence going to invoke the move on judicial role. Maybe if he didn't have that move available to him, he would then go back and contest the meaning of the Ninth Amendment. But that's not what he did. He conceded the meaning of the Ninth Amendment would apply to this right, and the Declaration of Independence would have referred to this right, but then shifted to judicial role. That's the shift between restoring the lost Constitution about what the meaning of the text is and our Republican Constitution, which is about the appropriate role of judges in a constitutional republic. It's addressing that shift. Now, the position that Justice Scalia, Bork, and others have taken is not an unprincipled one. But unfortunately, it's based on principles that modern conservatives have inherited from the left. And by left, I mean the political progressives of the early 20th century. In my book, I devote a whole chapter, chapter 5, to the rise of progressivism and what I call the democratic constitution. Those who adhere to a democratic constitution view we the people as a group, or they view it collectively as a group that is entitled to rule according to its will, the will of the people we hear. But the will of the people can only be the preferences of a majority of the people. It can't be everybody's. We can't require unanimity. So the will of the people in practice must be the will of the majority of the people. And a democratic constitution under this view of we the people is therefore needed to establish mechanisms by which the preferences of the majority can be represented, and then that's another way of saying, representatives are representing the people, that can be represented and then enacted into law. And anything that interferes with the will of the majority, here's the key point, anything that interferes with the will of the majority, like unelected and unaccountable judges, is suspect. It's called the counter-majoritarian difficulty in constitutional law theory. The counter-majoritarian difficulty. What gives unelected, lifetime-appointed judges the power to thwart the will of the people as manifested in legislation democratically enacted, properly so. This should all sound very familiar to you. I'm trying to paint a realistic picture of this vision. Now, this was the argument made by political progressives against a judiciary that was then obstructing their effort to achieve their political agenda. In the book, I tell the story of how progressive presidents like Republican Teddy Roosevelt, Democrat Woodrow Wilson, Republican Herbert Hoover, and Democrat Franklin Roosevelt loaded the Supreme Court with like-minded justices. All of these were progressives, Republicans and Democrats. We got a Republican Teddy Roosevelt, progressive, Republican Woodrow Wilson, progressive, Republican Herbert Hoover, progressive, Republican Franklin Roosevelt, progressive. The court-packing scheme, the theory, the story you've been told about the court-packing scheme creating this big switch in the Supreme Court, there may be a grain of truth to this, but by and large, the Supreme Court was remade by four Republican and Democratic progressive presidents long before beginning long before 1937. It started way back. And the book tells the whole story about how this was done and the role that Teddy Roosevelt in particular played in promoting this idea in the beginning. And then I explain in the book how so anyway, they loaded the court with like-minded justices, and then in the book I explain how in 1946, after the Republicans took control of Congress, which we sometimes forget happened, some on the court began backtracking from their commitment to judicial restraint. All of a sudden, deferring to the popular will of the democratically elected majority didn't sound so good when the Republicans were going to take charge of Congress. So some on the court started to have second thoughts about this. And for deviating from what had been the progressives' line favoring judicial restraint, these justices, who happened to be associated with the Yale Law School, were labeled judicial activists by progressive historian Arthur Schlesinger Jr. in a fascinating 1947 article in Fortune magazine that I discuss in detail in the book. So the term judicial activist, so far as we can tell, stems from Arthur Schlesinger Jr.'s article. A good New Deal progressive historian, Arthur Schlesinger Jr., associated with Harvard as opposed to Yale, who distinguished on the court between those members who he referred to as lions of judicial self-restraint and the judicial activists. The judicial activists he did expressly associate with the Yale Law School's School of Legal Realism, and then he didn't mention that the justices that were the restraint justices were associated with Harvard Law School, as was Justice Oliver Wendell Holmes Jr., who was a professor at Harvard Law School before he went on the bench, and then he preached judicial restraint then. So There's a lot more to the story. There's a whole chapter of the book which explains this part of it, the story. When the modern conservative political movement arose in the 1950s, 60s, and 70s, conservatives embraced the stance of the judicial restraint progressive justices, the judicial restraint progressive justices of the New Deal, against that of the activist progressive justices of the Warren Court. So that's what the big debate always was about. Which New Deal justices were right? The restraint New Deal justices or the activist New Deal justices? But it was a choice between New Deal justices, post-New Deal justices, and people chose sides as to which side of the New Deal court was the correct side. Even as Republicans, these conservatives were small d Democrats, adhering to the Democratic Constitution's vision of we the people as a group. Now, this may have been the only respectable choice to make back in the day when one was a law professor or a student at an elite law school. But it was a false choice nonetheless, even then. What was lost was the vision on which our Republican Constitution was based. The vision of we the people as individuals. We the people as individuals. Now, it's revealing that Justice Scalia, in his Troxel dissent, cited the Declaration of Independence only to dismiss its relevance as law. As I explained in Chapter 2, which is devoted almost entirely to the Declaration was the founding document of the United States. It's what made us a separate country. Then, at that point, came a couple of tries at government, first under the Articles of Confederation and then under the U.S. Constitution, and then subsequent amendments which altered even that. But what made us a country was the Declaration of Independence. What made us a people was the Declaration of Independence. And the Declaration of Independence declared the fundamental principle on which this country was founded, and that is, first come rights, and then comes government. First come rights, and then comes government. First comes we the people as individuals who are endowed with the unalienable and individual rights of life, liberty, and the pursuit of happiness. And then, quote, to secure these rights, governments are instituted among men. To secure these rights, these individual rights, governments are instituted among men, therefore stating the relationship between government and rights, the rights retained by the people. Now, these governments who are established to secure these rights are not us, and they do not express our will. Governments, instead, under this vision of the Constitution, are our servants who are tasked with the job of securing our rights as sovereign individuals. A good constitution under this vision is a Republican constitution that both empowers a government to energetically secure our rights. So first, it's there to empower government to secure our rights from being violated, and then, at the same time, it protects these rights from being violated or infringed by our servants or agents. So we are the people, we are the masters, and the Constitution is there to provide the law that governs those that govern us. Here's a copy of the Constitution. It's the Cato Constitution it's sometimes referred to. It's very ubiquitous. It's everywhere. It's been distributed by the millions, right? I like the Cato Constitution especially because it randomly inserts the word liberty into the text of the Constitution. It doesn't really do that. I just say that because I like to say that. It's actually the actual literal Constitution. Doesn't put that in there. Anyway, this is the Constitution of the United States. This is not the law that governs us, except for the 13th Amendment, which actually does stop us from doing stuff like owning other people. Other than the 13th Amendment, this is the law that governs those who govern us. This is the law for them. Then they turn around and make laws that govern us. But this is the law that governs them. And those who govern us can no more properly change or ignore the law that governs them without going through the amendment process described in Article 5, then we can change or ignore the laws that govern us without going through the legislative process. We can't just ignore the law because we don't like it. There's not a living speed limit. a living and evolving speed limit that we get to interpret. Maybe the cop gets to interpret it, but we don't get to interpret it. We have to go through the amendment process. Under a Republican Constitution, then, judges are also servants of the people who have a job to do. Their job is to keep all the other government actors in line. Their duty is to enforce this Constitution to which they and all other governmental actors take an oath. We don't take an oath to this Constitution, but each and every government official, state and federal, takes an express oath to this Constitution. That's unanimous consent by them to adhere to this law. We don't unanimously consent to it, but they do. A Republican Constitution, under a Republican Constitution, judges have a role to do as our agents, and that is to enforce this Constitution against any law that exceeds the just powers of any Republican legislature. The Declaration goes on, by the way, to secure these rights. Governments are instituted among men, deriving their just powers, not any power, not all powers, not unlimited power, not plenary power, but their just powers from the consent of the governed. In a conflict between an individual member of the sovereign people, us, and their servants in the legislature, them, judges are supposed to provide what Madison called independent tribunals of justice, independent and impartial tribunals of justice. But this was not the view of judges that modern conservatives adopted. Between their commitment to judicial deference to majoritarian rule by legislators, to their acceptance of precedent that they admitted to be contrary to the original meaning of the Constitution, to their insistence that whole clauses of the Constitution were unfit for judicial enforcement, judicial conservatives gave us a very tepid commitment to the original meaning of the Constitution. And then they gave us Chief Justice John Roberts. Now, I believe that John Roberts is a good and decent man. I know he was a brilliant Supreme Court advocate, some say the best. And though I've only met him a few times, I would be happy to have him as my friend, although I have doubts that's going to happen in light of my giving this speech. But John Roberts was selected by President George W. Bush because he was a judicial conservative who hewed to the doctrine of judicial restraint, or what he himself called judicial minimalism. In my book, I explain how that commitment to judicial restraint gave us Obamacare. On the one hand, Justice Roberts affirmed, he was the fifth vote to affirm the Republican limits on the scope of federal power by holding that individual purchase mandates were beyond Congress's power under the Commerce and Necessary and Proper clauses. Then he turned around. In fact, everybody in the court that day, I was fortunately not in the court that day, but everybody in the courtroom, I was in the court for 3 days of oral argument, but I was not there the day the decision was handed down. I had so many press inquiries and op-eds I had to write that I needed to be in my office in order to do all of that, and I couldn't be in court. But those who were in court and heard him read his opinion from the bench and heard him read the first part of his opinion from the bench thought the challengers had won. And in fact, CNN and Fox News both falsely reported that initially that the challengers had won. I got a text message from my mom while I was in my office saying, "You won, you won, you won." And I was following the case on SCOTUS blog, and I knew we hadn't won. And I said, "Mom, I'm sorry, we didn't." But she said, "But Fox said you won." I said, "Sorry, we didn't win. We didn't win." Yeah, that's how pro our position the first half of the opinion was when he read it out loud. But then he pivoted. He then invoked the Democratic Constitution's mantra of judicial restraint, adopting what he called a saving construction that turned the individual insurance requirement enforced by a penalty, those are the words of the statute, it's a requirement enforced by a penalty, into an option to buy insurance or pay a modest and non-coercive tax. Now, as he put it, which he called a reasonably, he conceded in his opinion that was not the natural reading of the statute, but he characterized it as a reasonably possible reading of the statute, and that was enough. That was enough to sustain it. As he put it, granting the act, quoting, quote, "Granting the act the full measure of deference owed to federal statutes, it can be so read as an option enforced by a modest tax." And he then defended this move by insisting that, quote, "It is not our job to protect the people from the consequences of their political choices. It is not our job to protect the people from the consequences of their political choices. I'm going to come back to that sentence in a moment. Now, perhaps he believed, or he expected, that this split-the-baby approach would be received by conservatives with equanimity. But it wasn't. Many on the right were outraged because they believed it was the job of the Supreme Court to hold Congress to its enumerated powers, and thereby protect the liberties of we the people even from a majority in Congress who had enacted Obamacare. In this way, the Obamacare decision was a political inflection point in how conservatives conceived of the role of judges. As a result of Roberts upholding Obamacare in the name of judicial deference, the trend of opinion among conservatives has decidedly moved away from judicial conservatism and restraint. The movement has been palpable, I should tell you, and towards what is best called constitutional conservatism, which favors judges enforcing the original meaning of the text, even if this means invalidating popularly enacted laws. But sadly, we now see that while John Roberts' ruling in the Obamacare case led constitutional conservatives to turn against judicial restraint, it also has caused Republican voters to turn against constitutional conservatism, and even, in some cases, against the Constitution itself. In order to see this, let us recall the state of American politics leading up to the Obamacare decision. A popular movement called the Tea Party arose spontaneously to oppose the Bush bailouts of the banks and car companies. Then, with the election of President Obama, it turned its attention on the Democratic efforts to finally achieve their dream of putting the government in control of our doctors in the way that they have taken control of the teachers who educate our kids. The goal of both endeavors, in my view, was never either education or health. The goal was social control, to turn sovereign citizens into subjects and supplicants. Using the internet and free conference calling, the grassroots Tea Party organized nationally to resist this by employing the checks and balances provided by our Republican Constitution. The Affordable Care Act that emerged from the Senate, in my view, and in the view of many actually, was never intended to actually become law. It may surprise you to know that, but that's true. At least I think it's true. It was merely the means to get the health insurance bill out of the Senate and into a conference committee with the House where the real plan would be drafted and then sent back to the two chambers for approval. However, by electing Scott Brown, Tea Party activists in Massachusetts, mind you, had made this impossible by depriving Senate Democrats of their filibuster-proof majority. I mention this because I want to stress to you what the politics look like as a result of this. It was Massachusetts that stopped Obamacare legislatively by sending an anti-Obamacare Republican senator to the Senate to deprive the Democrats of their 60-vote majority. At that point, either the House had to accept the Senate bill, to which many of them objected, because they wanted either single payer or they wanted a public option, but they didn't like this Rube Goldberg contraption that was contrived in the Senate. Or if they didn't accept it, there would be no fundamental transformation of our healthcare system, which of course they wanted more than anything. More than good policy, they wanted the fundamental transformation, so that was their choice. This or nothing, though they chose this. By the time the House swallowed its pride and accepted the Affordable Care Act, the states in our Republican Constitution mounted a challenge against the law on that very theory that we had presented in our Heritage Foundation legal memorandum. In fact, the book tells the story about how it was Texas Governor Greg Abbott who called me in January. The bill, we devised our argument in November, we presented it in December, the bill is passed in December, and in January I got a call from then Attorney General Abbott asking me, what can we do? What can we do to stop this? What can I do as an Attorney General of a state to stop this? And what he then did is he got together with Bill McCollum of Florida, who is the AG of Florida, and they organized the Attorney General into this lawsuit, which eventually resulted in 26 Attorney General opposing the constitutionality of this bill. And there was 2 more states that had their separate challenges, bringing the total number to 28. Oklahoma and Virginia didn't join the joint suit. They had their own suits. And while that lawsuit was pending, the Tea Party elected enough new constitutionalist members of Congress to flip the House to Republican control, ensuring that if the law was invalidated by the Supreme Court, a single payer or some other variation on socialized medicine could not be enacted. And let me just point out, it's not in my prepared remarks, but let me just point out, we had no constitutional argument against such a plan. None. There would be none. There is none. Under existing doctrine, not under original meaning of the Constitution, under precedents that the conservatives would not disturb, but under the precedents we were relying upon, if it had been a single payer plan, we couldn't object to it. Why? Because if Medicare is constitutional, then Medicare for everyone is constitutional. And the fact that Medicare is constitutional is not subject to question at this point. It is not unprecedented. There's a precedent for it. So we got them because of the individual insurance mandate. If they had come back and repassed it the other way, and I conceded this for 2 years debating this case. If somebody said, well, if Congress had passed a single payer plan, would that have been constitutional? Would you have an objection to it? I said, no, we would not have the same objection. The only objection we could then make is based on the original meaning of the Commerce and Necessary and Proper Clause, but we know that's not going anywhere with the court we had, including the conservatives on the court. But nevertheless, the Tea Party movement guaranteed, by flipping the House to Republican, that if it got sent back to the House, that was not going to happen. That was not going to happen. And they did that despite their activities, their organizational activities being suppressed by Obama's IRS. They still were able to do it. Now, for 2 years during this lawsuit, the nation was transfixed by the challenge to Obamacare. Transfixed in a way that has not happened in the lifetime of anyone in this room. I don't care how old you are. There's never been a Supreme Court case like this. By and large, the public only finds out about a Supreme Court case if they pay any attention at all after it's decided. Those insiders might know about the case when it's argued in the Supreme Court. Then people who follow the issue closely might know about lower court decisions. This was a case where the whole country followed every decision that was made. And by whole country, I mean people who are aware of public affairs. Obviously, I don't literally mean everybody. That Jay Leno interviews, or Waters interviews for Waters World. I'm not talking about those people, but I'm just saying everybody who knows what's going on was following this case. A genuine popular constitutionalist uprising had set the stage for a renewal of our Republican Constitution. It wasn't just activists or theoreticians or inside the Beltway think tank people talking to each other anymore. There were actual, real, living, breathing American citizens who really cared about what was going on and who were listening to us. Tea Party activists and just plain old Republicans looked to the Supreme Court to uphold a limit on the growth of federal power. Now, it's true that Democrats and the left intelligentsia would have screamed bloody murder, as they actually did do after 3 days of oral argument indicated that we had 5 votes to invalidate the law, had the court invalidated the law. But had the court invalidated the law, polls show that it would have enjoyed, that decision would have enjoyed the support of a majority of the American people. And, most importantly, it would have taught the American people an invaluable lesson about their Constitution and the courts. No Americans knew about the Gun-Free School Zone Act that the Supreme Court had invalidated in 1995 in the Lopez case. You probably don't know about it. Most Americans were clueless about the civil cause of action for gender-motivated violence that the Supreme Court invalidated in 2000 in the Morrison case. You all might not know about that. And only a minority of Americans truly cared about the use of medical marijuana that the court had failed to protect in the 2005 case of Gonzalez versus Raich, which is the case that I argued in the Supreme Court. Only a minority of Americans cared about that. But virtually everyone who paid any attention to public affairs were aware of our challenge to Obamacare. Had it been invalidated and the decision remanded to a now divided Congress to devise a new and perhaps even a genuine reform of existing regulations of insurance, it would have shown the American people that there were indeed limits on the power of Congress and that those limits were enforceable. Perhaps, even most importantly, it would have shown the Tea Party constitutionalists that their efforts had finally paid off. They had put their faith in the Constitution and in their courts, and that faith was rewarded. But instead, what they got was a good, hard kick in the teeth. And it was my wife who made me say kick in the teeth. As a former Cook County State's Attorney, my first reaction was to use a different expression. And the effect of that kick was felt in Indiana during the Indiana primaries and the primaries that led up to it and to today. Listen again to the words of John Roberts to the Tea Party activists who were counting on him. Quote, "It is not our job to protect the people from the consequences of their political choices," unquote. Now, what else did that mean to them? If not, it is not our job to uphold limits on federal power. Go away from the courthouse. Go away from the judges. And go away from the Constitution itself and fight this out amongst yourselves. Now, law exists in part to direct the natural urge for self-preservation and self-defense into peaceful channels. The Constitution exists to provide the law that governs those who govern us. And the judiciary was created, in part, to hold the government within its just powers, and by so doing, avoid the Hobbesian political war of all against all. But at the very moment he was called upon to teach the American people of the value of their Republican Constitution, Chief Justice John Roberts asserted the judicial restraint of the Democratic Constitution and turned them away. And that, my friends, was the end of our constitutional moment. That was the beginning of the end of constitutional conservatism as a grassroots political movement. And it contributed to kindling the resentment and populism that led us to Donald Trump. Now, when I began law school, I loved the Constitution. And then I took constitutional law. And in constitutional law, I read Supreme Court opinion after Supreme Court opinion explaining how every clause of the Constitution that limited federal power didn't really mean what it said. And we were taught that every Supreme Court case that reined in federal or state powers, like the much vilified case of Lochner versus New York, was evil and to be repudiated. By the time I had finished constitutional law, my constitutional law class, I myself was finished with the Constitution. If the Supreme Court did not care about the Constitution, I concluded, then why should I? When I became a law professor, after first being a criminal prosecutor, which is what I went to law school to become as a criminal lawyer, and then I became a criminal prosecutor in Chicago. When I turned to becoming a law professor and wanted to do something other than criminal law, I became a contract scholar, not a constitutional law person. I had no intention of doing constitutional law. And only gradually and very reluctantly did I become involved in constitutional law. And it's a long story, but it had to do with the Federalist Society got me somehow involved. Went little by little, and I got my tie caught in a ringer, and eventually, here you see me right now, a constitutional law guy. But I was against it. I was first invited to, one little digression, I was first invited to speak at the 5th Annual Federalist Society National Student Convention held in Stanford, and as a relatively obscure law professor, contracts professor from Chicago College of Law, I really wanted to accept the invitation, but I told the student who invited me, "I'm sorry, Brian, you know I don't do the Constitution." And he said, "Oh, come on. You only have to talk for 10 minutes. You're a smart guy. You can think of something to say for 10 minutes. So I said, okay. Okay. I wanted to go. There was all these big-name people who were going to be on the program, so I went, and I gave a talk. And the punchline of my talk turned out to be the Ninth Amendment, about which I really knew nothing except what it said. And it was a result of that I finally decided, well, maybe I'll learn something about the Ninth Amendment. And then one thing led to another. I could tell a whole story about how that led to the Obamacare challenge. But I won't. Maybe in question and answer, but it's in the book. I mean, actually, this isn't in the book. I take it back. Doesn't matter. So I said, why should I? If the Supreme Court doesn't care about the Constitution, why should I? What good was the Constitution? Why bother with the Constitution? In some, like the critical legal studies movement of the 1980s, Chief Justice Roberts told the people that there were no constitutional limits on federal power. There was only politics. That's what CLS told people. Law was just politics. There's only politics. That's what Roberts said. There's only politics. Go away. There's only politics here. Now go out and get your own Obama to right whatever wrongs you think you suffer. And now they have. And their new political paladin's name is Donald Trump, a man who knows nothing about the Constitution and who couldn't care less. Now, it's hard to think of two people who are as different from each other as the well-mannered John Roberts and the crude Donald Trump. Yet in the end, they both believe that courts ought to bend a political will, at least when the chips are down. Donald Trump is what John Roberts told Republicans they needed to find. And then they found him. So now what? What do those of us who still believe in our Republican Constitution do now? Now, I don't pretend to have all the answers. Heck, I'm really not sure I have any answers. But I'm going to tell you what I recommend in the conclusion of our Republican Constitution. And here's quoting from the book. The first thing we need to revive our Republican Constitution is to remember our constitutional heritage. And this, frankly, is the purpose of this book I wrote. And by that, I mean to provide a Republican narrative that begins at the founding and carries through to the formation of the anti-slavery Republican Party that greatly improved the Constitution by providing much-needed federal constraints on state power, and to remind us of how progressive justices replaced our Republican Constitution with their democratic one, with the exception of certain favored rights that the activist progressive justices deemed to be fundamental. So now, judges are in the position of having to pick which of our liberties are fundamental and get protected and which of them are not fundamental and do not get protected. That's what they do now. In short, conservatives and libertarians need to rediscover the difference between a democratic and a Republican Constitution. Remember, if it was John Roberts who gave us Donald Trump, it was judicially conservative Republicans who gave us John Roberts. Second, we need what I call in the book a Republican politics and a constitutional Republican Party. For better or worse, our Republican Constitution provides the process of selecting judges, that the process of selecting judges and justices will be a political one by design. An elected president nominates judges and an elected Senate confirms them. Our Republican Constitution, therefore, will not be restored in our two-party system until one of the two major political parties embraces it as a central plank of its political platform. Now, the natural home of the Republican Constitution is the modern Republican Party, the antecedent of which was responsible for completing the work that the founders had imperfectly begun. This is not the Republican Party of today. It is the reason, by the way, that this year, for the first time ever, I worked for a presidential candidate. I worked for Rand Paul, who asked me to help him out on his campaign because he does believe in our Republican Constitution, and he's expressed that belief on the floor of the Senate. And when he asked me, even though it's not the kind of thing I normally do, when he asked me to do it, I thought, this is the most libertarian and constitutionally inclined candidate for the presidency I'm probably ever going to see in my lifetime. So I better help him if he wants my help. But he didn't make it. And then Ted Cruz, who I also believe, who I know and I believe is a constitutional conservative, he didn't make it. And now, I had really hoped that one of the constitutionalists who were running for office, one of the people who were friendly to constitutional conservatism would win the nomination. There were several of them running besides those two. And they would win the nomination, and then that would be the vehicle by which we could restore the Republican Party to being a constitutional Republican Party, which it isn't, but we could make it that way. But the rise of Trump threatens to purge the party of any commitment to constitutional conservatism at all. However, I think that if the existing Republican Party will not be a constitutional Republican Party, then we need to replace it with a new party that will, not a third party, a new second party. Parties die. The Whigs died. The Whigs died because they couldn't handle the slavery issue, the extension of slavery into the territories. They just couldn't handle it. So they collapsed in favor of a new Republican Party. Parties die. And we'll have to see what happens. The Republican Party could die, but it needs to die if it won't be a constitutional Republican Party. It needs to be replaced by one that is. Now, I confess that when I wrote the book, I had in mind constitutional Tea Party candidate like Rand Paul or Ted Cruz, elevating the constitutional wing of the Republican Party over that of the GOP establishment, who deserve a lot of the blame that's being placed on them and are responsible as well for the rise of Trump. But really, John Roberts is part of that establishment as well. But now, thanks to the anti-constitutionalist populism unleashed by John Roberts and the others, we have Donald Trump. So now what? In all candor, I am uncertain myself, and we can talk about this. We're going to have time for discussion amongst ourselves, this small, intimate group here. On the one hand, the temptation is strong to support Trump over Clinton in the hope he will pick a constitutional conservative to replace Justice Scalia. And we can talk more about it during the Q&A, but the list that he presented, and I have some idea of where that list came from, which I can't say, but I have an idea where it came from. But the list is a very good one. It's a good list. I don't know every judge on the list. The ones I don't know make me a little suspicious of the ones I don't know, but I mean, the ones I do know are really quite good, really, really quite good. They'd be justices I would recommend myself. If Hillary Clinton's elected, we can be assured of losing the court for a generation. And the names that Trump volunteered at the debate and on his list, like Judge Dianne Sykes of the Seventh Circuit or Bill Pryor, would be excellent picks. However, I don't have complete faith in Donald Trump choosing one of these persons to be a judge, any more than I really have faith that he's going to build a big, beautiful wall that he promised. Especially when someone explains to him that a constitutional conservative judge is there to say no to him. Then he might go back. And what would he do, by the way? When that was explained to him, then what judge he would pick? He'd pick a good, old-fashioned conservative judge. And you know who'd get behind, who believes in judicial restraint and not saying no to the executive and not saying no to Congress? And what would conservatives do when faced with such a choice? They'd support him, because whoever it picked could be quite eminent as a conservative judge. Because that's like John Roberts was quite well thought of as a conservative judge. And if Donald Trump picks one of those, he'll be picking a good conservative. And so conservatives who believe in restraint won't oppose him for that. He's got an out. He's got a way of both honoring his promise and still picking judges that won't say no to Donald Trump. Perhaps the need for a constitutional Republican Party argues for sitting out this election. If Trump is elected, then the populism for which he stands will be vindicated, and the Republican Party stands the risk of being remade in his image as a European-style right-wing nationalist party. And that would be the end of any hope to revive constitutional republicanism within the Republican Party for years and years to come, if ever. Somebody over there said, or ever, and I agree, if ever. But if Trump should be defeated, and with him his populism, a new Republican Party must take the lesson of our Republican Constitution to heart and reject the constitutional conservatism and deference that conservatives inherited from the progressives. It must embrace the constitutional federalism and separation of powers that are the structural ways we protect the rights retained by the people. And it must also embrace an engaged judiciary who will enforce all the strictures of our Republican Constitution to protect the individual rights of we the people, each and every one of us. Thanks.
Thank you, Randy. That was a wonderful talk. I should tell you that last night, Randy came to me and said that he wanted to change his talk, right? And he and I had negotiated a topic months ago, and last night he says, I want to change it. And I said, to what? And he said a much edgier talk involving Donald Trump. And I thought about it, and I thought, okay, whatever. And I'm glad, delighted that he's given that talk. That was fantastic. Thank you very, very much. So we have about 17 minutes for Q&A. But let me just say that when we are done in this session at 10:15, I'm going to rush Randy out of the room, so please don't come up to ask questions. I'm going to rush him out of the room so we can get the books out and get him signing books right away, because our next session will start 20 minutes after the end of this Q&A. So why don't we just start with the Q&A right away?
So don't think you're going to sit back and ask me the question privately, because you're not going to get a chance to, so you're going to have to ask me now. And I'm going to try, keep your questions short. I'm going to try to keep my answers short. The challenge will be on me, because my answers tend to get long. Nigel?
Yeah, Nigel Ashford, Institute for Humane Studies. You said that you thought there had been a recent shift away from judicial restraint.
Yes.
What evidence do you have of that? And how confident are we of at least the people that Trump did mention are people who are shifting away from judicial restraint?
Great question. I'll try to be brief. I debated Court of Appeals Judge J. Harvey Wilkerson in the Federal Society National Lawyers Convention like 2 years ago. And if that debate had happened 15 years ago, and he defended judicial restraint, and I defended engaged judiciary, and if that debate had happened 10 years ago, I would have been the deviant dissident, and he would have had the room. By all accounts, including by the leadership of the Federalist Society who organized the meeting, there was absolutely no question that I had the room, and he did not. And the room included lots of distinguished appellate court judges. George Will was there. I don't know if you've read, George Will wrote the foreword to my book. George Will used to be an advocate of judicial restraint, and he is no longer. So it's just my systematic impression as somebody who's been a minority in the conservative legal movement and now considers, and I know what it feels like to be marginalized, and now no longer feel marginalized, that this shift has happened. The judges on the list, the ones that I know, some of the ones that I know, I'm quite confident are not judicial restraint judges. They are originalist judges, and originalist judges will enforce the original meaning of the Constitution. The ones I don't know are the ones I'm not sure of whether they have this view or not, and that's the ones I can't be sure about. But I do know there were a couple of judges left off the list who had upheld Obamacare in the lower courts. And I don't think their omission from that list was accidental or inadvertent. Yes?
Good talk, Randy. Thank you. Apropos your comment about knowing better this lineage of historical constitutional analysis, what would you say to the following comment, that the liberty movement has so overemphasized the Jeffersonian approach versus the Hamiltonian? And knowing that from Federalist 78...
What do you mean by the Jeffersonian approach?
Well, from Hamilton's Federalist 78 Judicial Review to John Marshall to Justice Story, there's a tradition there of empowering the Supreme Court to strike down these very populist, democratic, Rousseauian type arguments. But if you look at the modern libertarian liberty movement, it is suspicious of Hamilton, but at least, and for whatever reason, in this particular realm, that's really where we need to go, versus this Jeffersonian general will, nullification. And so what do you think generally about the Hamiltonian judicial review aspect of it, which is not the same as judicial restraint?
Okay, the book does discuss this in detail. I will say Hamilton did make this argument you describe in Federalist 78, but I would not say it's a Hamiltonian position per se. It was standard garden variety position of everyone at the time of the founding, as I explained in the book. He was just articulating it in Federalist 78. And there's a lot of stuff he says in the Federalist Papers that if they had known they were not anonymously, if they had known who the real author was, they were all synonymously published. If they had known who the real author was, people would not have believed it would be Hamilton who said these things, because he was known to be such a big government nationalist. And as for Justice Story, it was Justice Story that upheld the Fugitive Slave Act of Congress in the name of deference himself, so he deserves some of the blame. He's not a hero of mine either. Neither is Marshall, even though Marshall decided Marbury versus Madison correctly. At any rate, I generally agree with the thrust of what you have to say. Conservatives have accepted a restraint interpretation of what was going on in the early days. And then the book describes the rise of the modern Democratic Party, which only happens in the 1820s. We think of it as because they like to talk of themselves as having a lineage directly back to Jefferson. And it's true, some elements of the Democratic Party were on the Jeffersonian side, but the Jeffersonians called themselves Republicans, not Democrats. The historians call them Democratic Republicans, just so you don't get confused. But it was the Democratic Party that was founded post-Jackson and Monroe that really established and expressly advocated what he called the will of the majority. And they cited Rousseau, popular will, and claimed that, Van Buren claimed, for example, that was what the founders actually believed in. I think that's ridiculous. And then they used their notion of popular sovereignty to defend the power of the people, or the majority in the territories, to decide whether they could own other people or not. That's how much they were committed to democratic majoritarianism. That was what they called popular sovereignty in the territories. And the Republican Party was established to fight that and to question that. And the book tells that whole story. So yes, we need to recapture exactly what you're talking about. But some of the people that were thought of as heroes, we think of as heroes, were not actually as heroic as we might believe. Yes?
Great talk, first of all. Second, follow on kind of to the question before, but so I found your quote of Schlesinger fascinating in a lot of reasons, for a lot of reasons, not the least of which is that if you've really looked at this history as you have, you know that judicial restraint really started, modern judicial restraint started with the progressives, so it's not surprising at all to see somebody like Schlesinger saying that in 1946, 1950. Excuse me, but the question is, the Republicans or the conservatives seem to have adopted that mantra so quickly after that point. I mean, you have Raoul Berger and then later on Bork and many of the others. So why did they gravitate to that so quickly? Why did that become such a Republican or conservative mantra, certainly up through the 80s and really, I mean, up to, through the point at which John Roberts was educated?
Right.
Why? What happened there?
It's probably too long a story. In the time we have, I won't be able to get to other questions. I will tell you, I met Raoul Berger. I have the privilege of having a Raoul Berger article criticizing me, and my name is in the title. It's called "The Ninth Amendment According to Randy Barnett" by Raoul Berger. And I met him, and he was a very pugnacious writer, but in person he was kind of a kindly old man. And but he did tell me that he was a New Dealer then, and he was a New Dealer today, and he would be a New Dealer to the day he died. That's Raoul Berger. That's the kind of conservative he was. He was a New Dealer. And there's good reasons for why. I mean, there are explainable reasons why conservatives did it. First of all, they were opposed to the Warren Court's activism on substance. And the idea of criticizing the Warren Court for activism is a shortcut to being able to criticizing a court for being acting against the original meaning of the Constitution. The alternative, the reason why judicial restraint and judicial activism are such convenient terms is because you can criticize an opinion without knowing anything about the correctness of the opinion. All you have to do is say they invalidated a popularly acted law and they've gone beyond their role, and you've got your soundbite for television or radio. You don't have to explain why what they did was wrong under the law or under the precedent, under the doctrine. So it's a real convenient shortcut for them. And they just objected, and what really amped this up was Griswold versus Connecticut, and then Roe versus Wade, which they could criticize on the grounds that judges should not be interfering with the will of the people. And that gave them a very nice, easy answer to what was wrong with those cases, rather than have to do the hard work of explaining why constitutionally they may be right or wrong. And they may be right or wrong, but that's a different thing. So that's really critically, I think, when it was already happening, but that's when it really took hold.
Thanks.
Yes?
Lots of questions. Really enjoyed the talk. One question: the Supreme Court's power review, I think, is a little ambiguous in the actual document of the Constitution, at least in my view. And since you had already addressed that twice, I thought I would ask you a different question, which is
okay. Well, I didn't really address. Let me just say, because I can't address it here, it's a conservative canard, that the so-called power of judicial review is not in the Constitution. For one thing. It was not thought of as the power of judicial review. That was a progressivist idea, the power of judicial review. It was a duty of the courts to follow the law, is what they had at the founding. If you look for the power of judicial review at the founding, you won't find it, because it was the progressives who invented the words. But if you look for duty to enforce the law, you'll find it everywhere. In fact, you'll find it in Philadelphia, and there was not one person at Philadelphia who questioned whether judges would have the power to nullify unconstitutional law. Not one. And in my book, my last book, Restoring the Lost Constitution, I give all the examples of the debates that presuppose judges would have the power to nullify unconstitutional laws, including the fact that they rejected a council of revision because they said, First of all, it would compromise judges to be put on the council, which is supposed to be able to reject laws on the basis of policy, not just constitutionality, because then it would come before them again as on the basis of constitutionality. And secondly, they're going to get to hear it in due course anyway, so you don't need a council of revision. It was rejected. Only one delegate in Philadelphia raised any questions about judicial review, and he didn't deny it existed. He just said he didn't like the idea. And then another delegate said, well, I can understand why you're saying that, but what other choice have we got? All right, so I just want to get that out of the way, because conservatives have been taught for many years that it's not in the Constitution. It is. It's part of the judicial power, which is given to the judiciary. Now, what's your question?
No, I think that's fair enough. Yeah, those good answers.
Okay.
Let these guys have a
Okay,
chance.
thank you. Yes.
Hi, I'm Abir Mandel from Clemson University.
From Clemson?
Clemson, yeah.
Great.
And my question is that you call the Obamacare mandate, as enforced by the penalty, invoked by the IRS as unprecedented. How is it any different than, for example, the tax credits given to us for mortgages or the mortgage interest or student loan payments? How is it like anything like materially different than that?
Well, I can tell you after 2 years of arguing this case that we could get into a very long discussion of whether it's precedented or unprecedented and what the difference is. But I will say that nobody makes you get a mortgage. They do say that if you get a mortgage, you'll be able to save some money on your taxes, but nobody makes you get a mortgage. The actual statute we challenged said it was a requirement that you get insurance and that it would be enforced by a penalty. That's the statute we challenged. The penalty happened to be a low monetary penalty in order to get it out of the Senate committee. But there was no principled reason why, no constitutional reason why it had to stay low. Under John Roberts' ruling, of course, it sort of does have to stay low, or it'll be coercive, and then it'll be a requirement, and then it'll be a penalty, and therefore it'll be unconstitutional, assuming the court would ever enforce that. That's the logic of his opinion, assuming the court would ever enforce that. But under the terms of the statute, they could put you in jail for this down the road. They passed a low penalty to start with, and they're going to jack it up later for political reasons once they get the law in place. And then that is just not the same thing as a discount on your taxes you get as a result of doing something the government wants you to do. There's a principal difference between putting you in jail or fining you for not doing something they want you to do than to give you a discount off your taxes for doing something they do want you to do. Yes?
Andrew Cohen from Georgia State University. Thanks for the talk, Randy. I really enjoyed it. You made this remark that I found very intriguing. You said it was a Declaration of Independence that made us a people. And I wonder if you could elaborate a little bit on the notion of peoplehood that is behind that, because the wording might strike people as intriguing. They didn't say we, the aggregate of individuals who happen to be residing in this territory. They're saying we, the people. So how is it that the Declaration made us a people? Were they announcing that we were a people, or were they the actual Declaration itself is what constituted us as a people, and what might that mean?
Well, there's a lot there, and when I said that, I sort of wondered maybe I shouldn't say it quite that forcefully, but because it raises the kinds of questions that you just asked me. But at the very minimum, what it did is it separated us. I mean, look, I don't deny there is a people of the United States, and you can look at it as get into a spaceship, look down, and look at the group of the people who are the people of the United States. There's a group of people there. So yes, but the question is, what makes those, as you asked me, it's what makes the people a people. And at this point, it was simply a separate people from the polity that was from the United Kingdom or Great Britain. At one time, we were part of them. And then the Declaration said we're no longer part of them. We're our own thing. And that's all I meant by that. It separated us politically. And in fact, after the Declaration was issued, somebody got up in the Continental Congress and says, "Sir, we are now in the state of nature." And what they meant was there is no longer any common rule between us and the people of Great Britain. They didn't mean they were a state of nature relative to each other, but we were in the state of nature relative to them. And so that's all I mean. We were now a separate group. Within that group, each one of us are individuals, have individual rights. The Declaration goes on after we the people and then describes that each one of us have inalienable individual rights to life, liberty, and the pursuit of happiness, and is to secure these rights that governments are instituted among men, deriving their just powers. So, I mean, you have to take the Declaration as a whole and see what the philosophy is of the Declaration, and that was the legal basis on which we left our former association with these other folks who we were no longer part of. Yes, sir.
Yeah, a great talk.
Thank you.
And I want to know, I understand why Justice Scalia said that he's not or not, but if we don't say that these unconstitutional depredations that Congress has made, mostly under the Commerce Clause, are unconstitutional, I mean, how can we really argue that that we ought to enforce the Constitution in other ways? I mean, from the standpoint of intellectual consistency, I mean, if we don't say that Medicare, for example, is unconstitutional, then how can we consistently, with a straight face, argue that other invasions of the Constitution shouldn't be made?
Okay, this is a really big question. It's a very good question. It's a really big question. I don't have time to answer it fully. I have 2 minutes, and I have one more question I want to take.
Okay.
But let me just say, it doesn't all have to be done overnight. It can be done one step at a time. Consistently, it can be done one step at a time as cases come before you, one step at a time. You basically, once you identify the end, which is the original meaning of the Constitution, you can then move constitutional law in that direction rather than move it away from that direction. And there's nothing really unprincipled about doing something correctly in a gradual manner, if that's what you choose to do. Whether or not Medicare is unconstitutional or not under the original meaning of the spending power, because it's basically a taxing and spending provision, it's not a Commerce Clause regulation. That's a separate question that I don't have time to get into.
Right.
But it could be constitutional,
Right.
actually, even under the original meaning of the spending power. And what really changed was the income tax amendment, which was done by Article 5, which gave the federal government the power to tax and spend in a way it previously did not have. And it was that power that gives them the power to do all kinds of things that we don't like. We may not like on political grounds, but we can't object to on constitutional grounds. Last question.
Given that, back to your original argument that against Obamacare, it would appear that maybe it even precedes Justice Roberts, and that would mean, of course, maybe we can never trust any of the Republicans ever again, and we should actually maybe looking at, I was going to suggest the Libertarians as a possibility, but the question comes down to, with the aspect of the desire to privatize Social Security. If we truly privatize Social Security, but mandated everyone take a portion of their money and now place it with a private company, isn't that exactly the same argument with a different context as the Obamacare? And yet, that's exactly what the Republican Party wants to do and has been wanting to do, and that might be the reasoning behind why Justice Roberts really needed to, from the Republican standpoint as opposed to a constitutional standpoint, uphold Obamacare. And I would like to hear your comment on that.
Well, I kind of agree with everything you said except the very last part. I don't think this figured into Justice Roberts' thinking at all. But at the beginning part is a very thoughtful observation that the privatization of the Social Security could actually take the form of a mandate. And in fact, it was the Heritage Foundation that actually gave us the original concept of the mandate. Their health policy shop, not their constitutional law shop, is the one who invented the concept of mandate. They were in the room when Romney developed Romneycare in Massachusetts, because this is what Stuart Butler, who's an old friend of mine, at the Heritage Foundation thought was a great alternative to socialized medicine, which he thought was inevitable. So you can't, rather than socialized medicine, do this, it would be better. And so do this, it would be better is kind of a reasonable policy thing to be for, but then there turns out to be a constitutional problem with that the Heritage Health policy people didn't see because they hadn't talked to their con law people. And if they had talked to their con law people, being good judicial restraint con law people back in the day, they probably wouldn't have gotten an objection from them either. But times change, and it might just be that this privatization would have the same problem that we said attached to Obamacare. At any rate, it's a great question. All these questions are great. They were also very succinct. I thank you all for your rapt attention. I'm going to rush out now. If anybody wants me to sign a book, I'm happy to do so. But you're all going to get copies of the book, so you don't actually have to buy it. Lucky you.
Randy, again, thank you for a wonderful talk.